Good afternoon, everybody. Welcome to this Greater China Legal History seminar series. Welcome to CUHK Law. It's my very special privilege to introduce today's speaker, my colleague, Professor Jyh-An Lee. Professor Jyh-An Lee is a professor and executive director of the Center for Financial Regulation and Economic Development, CFRED, here at CUHK Law. He holds a JSD from Stanford Law School and an LLM from Harvard Law School. Professor Lee has published widely in top journals, mainly focusing on topics related to intellectual property and internet law and AI and the latest development. He has authored and edited a number of books, including Non-Profit Organizations and the Intellectual Commons, that was published in 2012, Intellectual Property Law in China, published in 2021, co-authored with 3 other colleagues, and a co-edited version published with Oxford University Press in 2021, titled Artificial Intelligence and Intellectual Property. Professor Lee has been the legal lead of the Creative Commons Hong Kong chapter since October 2018. He's currently a member of the European Center for E-Commerce and Internet Advisory Board, and which is located in Vienna. And he's also a panelist of the Domain Name Dispute Resolution Panel of the Asian Domain Name Dispute Resolution Center. Professor Lee has been covered widely by the several news outlets, ABC News, BBC News, Bloomberg News, Financial Times, to name just a few. And his work has also been cited by the US Court of Appeals for the Fifth Circuit and the UK High Court of Justice. Last but not least, Professor Lee is admitted to practice in Taiwan. Today, Professor Lee is going to talk about historical developments of China's copyright law during the late Qing and the Republican period. The topic is From Copyright Norm to Copyright Law, the first copyright statute in the Qing Dynasty and Republican China. Thank you very much, Jyh-An, for doing this seminar for us. Over to you.
All right, thank you very much, Lutz. Let me first share my slides. It is my great honor and pleasure to be a speaker of this series, of which that I have been a big fan. I love history. I also love my field of intellectual property. So I have been trying to combine these 2 different interests together. So that's why that I'm now working on a paper. So this is actually a paper that I am co-authoring with my PhD student, Ms. Yang Li. And then the paper will be the base of this presentation. As Lutz just mentioned, the topic today is about the Qing Dynasty Copyright Code, which is the first copyright statute in the Chinese history. I try to present a very different argument from what we understand previously about the Qing Code. So when we start to discuss the so-called copyright law in China, there has been an old debate, which is that when did China first have its copyright law? There are actually different kind of arguments. So we do see some scholars that they claim that the first copyright regime in this country appeared in Tang Dynasty. That is around like the year 618, something like that. And then if you read the Tang Dynasty history, you will see how this argument was made. That was because Wenzhong Emperor, or Tang Wenzhong, so he issued a very important order at that time to forbid citizens from reproducing this kind of like lunar calendar, almanacs, something like that. And then that is kind of like the restriction of the printing or reproduction of some information. And some people view that as the first copyright order in the Chinese history. And then that order or that edict later became part of the Tang Code and then become part of the legal system. It's the law. And why Tang Wenzong or Wenzong Emperor made that decision, and that was followed by other emperors in Tang Dynasty, because that prohibition came from the idea that the emperor just thought that he was the only link between human beings and natural event, which is actually kind of something like the God. So something that is not explainable. And then for ancient Chinese people, the idea is that emperor means sky, and then normal human beings or normal citizens are not allowed to say anything without any permission about the sky. That is the idea of Tang Wenzong. And more people argue that the first copyright regime appeared in China. Is actually in the Song Dynasty. And why was that? As we understand, both Tang Dynasty and Song Dynasty were hugely influenced by Confucianism. If you want to become government officers in ancient China, I think including Qing Dynasty, you needed to take the national exam centrally managed by the government. If you pass that exam with flying colors, then you might have chance to be appointed by the emperor as a mayor or some other similar rank of government officers. So the subject of these exams are mostly about this Confucianism thoughts, and there were 9 very important books that would be tested in these exams. We called it 9 Chinese classics. Then in Song Dynasty, normal people were not allowed to reprint these 4 very important books, the so-called 9 Chinese classics. And there is actually a government order of that kind of prohibition, which is that you are not allowed to reproduce these 9 books without the permission of the Imperial College. That is the so-called Guozijian. And Chinese publishers also have started to include some marks on their publication, very similar to the so-called modern copyright notice in their publication to require authorization of reprinting since Song Dynasty. You can see this picture, so the upper one, which basically says, oh, this is my publication. You are not allowed to reprint or reproduce it. So very similar to the copyright notice. So the people who make this argument most vividly include one of our founding members of this faculty. That was Professor Michael Pendleton. He wrote a paper together with a leading Chinese IP scholar, Professor Zheng Chenshi, and they both argue that China actually had copyright regime very, very early as the Song Dynasty. But of course, these arguments, they are actually not majority. Most people actually believe the real Western contemporary copyright regime first appeared in China. That was in Qing Dynasty. That was actually very, very late because if you consider that kind of a government order in Tang Dynasty or Song Dynasty, the subject that was regulated was actually very, very limited. That was not the conventional copyright work. And government had that kind of regulation for some specific purpose to maintain, for example, the status of the emperor or to maintain the very, very high level integrity of the national exam. So that is not widely applied to different kind of literary work. So that is why most people don't think that is the real copyright regime. So that probably somehow just look like a regulation of the printing industry, or you might probably view that as kind of like a ancient censorship mechanism adopted by the government. And why most people believe the first copyright regime appeared in China, first in Qing Dynasty? Not only because of the law, but that is also because of the term. The Chinese term of copyright, which is 版权 or 著作权. So that actually first appeared in China in the year of 1898, and that is of course in Qing Dynasty. And then Qing Dynasty did issue that copyright law, the so-called copyright code of the Great Qing Dynasty in 1910. So we refer to that as the Qing Copyright Code. And that was a very comprehensive statute. So if you read the statute, you will see the statute, the language, the system looks actually very, very modern. So very similar to what we have today, the copyright law in many different jurisdictions. But unfortunately, the Qing Dynasty was overthrown the next year in a revolution led by Dr. Jyh-An. So officially, that law was only put into practice by the Qing Dynasty for about a year. And then you might be wondering, so if that is a very short-lived law, so is that really important, and why we need to care about the Qing Copyright Code? Of course, I need to tell you, the law itself still very, very important. After the Qing Dynasty was overthrown by the Dr. Jyh-An and also his colleagues, the law actually extended because the government of the new Republic of China announced an extension to a lot of the Qing Code, including the Qing Copyright Code, for another 3 to 4 years till the year of 1915. So the Qing Copyright Code was still effective after the Qing Dynasty. Later on, the Northern Warlord then just kind of like imitate the Qing Copyright Code, and they enact their own version of their copyright law. That is the so-called the copyright law of the Northern government in the year of 1915. But the statute looked very, very similar to that of the Qing Copyright Code. I think it's fair to say, basically, the Northern government just copied most of the Qing Copyright Code as its own copyright code. And that is the copyright law at that time. Later on, the Kuomintang government also followed the basic framework of the 1915 Copyright Code, the same of that in Qing Copyright Code. And the new copyright law published or passed by the Kuomintang government was in year 1928. And then you can see the law actually just evolved with different version, but the Qing Copyright Code is the first version, and both the Northern Government Copyright Code and the Kuomintang so-called Copyright Act of the Republic of China. So they actually still maintained most of the essence of the Qing Copyright Code. Later on, the law went to Taiwan with the Kuomintang government, and the law still has been amended again and again. But the framework was still the same as what we see in the Qing Dynasty Code. And after World War II and after the Civil War in China, there was no copyright law for many decades. But the Qing Copyright Code and its structure and its essence actually went to Taiwan, and it still lasted in Taiwan. So the background of this code, that is kind of like the main thing of the presentation today. I'm trying to make a different argument than some of the scholars. So many scholars argue that the Qing Copyright Code was enacted mainly because of the foreign pressure. A lot of foreign countries, they pushed the Qing government to enact copyright law to protect their economic interest in China. Because you can imagine in late Qing Dynasty, there were already a lot of foreign investors, and they also published copyright work, and they needed more copyright protection. So they went back to tell their government that China did not have any copyright. So it will be for our good interest to have some copyright protection. Otherwise, these Chinese people just copy our work for free, and we will suffer huge economic loss. So a very representative argument was made by Mr. Jyh-An, who used to be the deputy director of the state copyright administration in China. That is a very high-level copyright policy maker. So he made this argument, which is that Qing copyright code and other IP laws in late Qing dynasty were drafted under the pressure from the Western power and were aimed at protecting their economic interests in China. Therefore, they were a product of imperialist aggression against China. So in this kind of statement, you can have that feeling that China was actually a victim, kind of like in this background, and then China was forced to enact copyright law. That was a very common argument. And in my presentation and in my paper, I am trying to make a different argument because based on my study about the Qing copyright code, I argue there are much more dynamic and comprehensive kind of like a picture of this copyright legislation. So foreign pressure, of course, plays a very, very important role, but that is not the only or not the most important reason for that legislation. So my observation is based on three things. I will explain that later. So of course, I never denied the important role played by foreign countries at that time. And we do agree that a lot of the foreign countries, they have tried to intervene into China's domestic policy in late Qing dynasty, especially after the Opium War. But I argue that the Qing copyright code was legislated to protect Chinese interests, China's own national interests in accessing foreign knowledge. So it's not enacted under the force of foreign pressure, and the purpose certainly is not to protect these foreign authors. And this is my basis of my observation. First, I will later briefly introduce the political economy of the legislation. Before the legislation, there were a lot of interesting stories going on in the country, and foreign pressure, or those relevant to foreigners, is actually just part of them. And the second thing is that as a lawyer, of course, inevitably, we will read the statute. And by reading the statute, I can also tell you, so the statute did not mean to protect any foreign authors. And lastly, the law was very short-lived, as I just told you, but it still became effective after Qing dynasty. And there was a very important court, that was the mixed court in Shanghai, that continuously applied the Qing copyright code, especially in copyright dispute between Chinese people and foreign people. And based on those decisions decided by the mixed court, you will see when the court is applied the Qing copyright code, it's very hard for foreign authors to obtain any protection. So that is the basis of my argument, and I will explain them one by one. First, legislation process. The legislation process was actually pretty long. The law was enacted in 1910, but before that, Qing government had spent a lot of time preparing for that. In January 1904, the Ministry of Commerce started to prepare for the legislation by translating foreign copyright laws that include Japanese copyright law, German copyright law, UK copyright law, as well as the US copyright law. And then the Ministry of Commerce completed the first draft of copyright law the next year, which was later submitted to another government agency, that was Ministry of Education, for further review and public discussion. Unfortunately, for that round of legislative effort, that was not very successful. The Ministry of Education concluded that the draft was not good enough, and then we might need to have further discussion. So the draft was then shelved by the Qing government because the Qing government felt there might be something more important at the time, which was to have some regulation to regulate the publishing industry and the news censorship. So many people actually just view that as kind of like a copyright law as part of the same line of reason, which is to regulate the printing industry, the publishing industry, or somehow relevant to speech control or censorship. So this kind of like a delay of copyright legislation just signal the Qing government's priority of controlling the publication industry, then protect copyright. And therefore, some scholars believe that Qing Copyright Code was enacted to just supplement the regulations on the publication industry. So the legislation process of a copyright law resumed again in year 1907 and was led by a different government agency. That was actually a new ministry at that time, the Ministry of Civil Affairs, which was established in 1906 and became the highest administrative authority in charge of civil affairs, or the kind of like interior domestic affairs in the country. And in the meantime, some legal scholars, they started to discuss that whether we need to have a copyright law in the country. And many of them actually expressed a very strong viewpoint, which is that we support the idea of implementing and enacting a copyright law. A very representative scholar at that time was Mr. Tao Baolin. So he actively urged the government, copyright law was really important. There's no time for us to wait. You need to enact that as soon as possible. Otherwise, there will be huge harm suffered by China. And to better understand how copyright law operated in other countries, Qing government actually worked very hard. In year 1908, the government sent some delegates to attend the Berlin Diplomatic Conference on the revision of the Berne Convention. As we know, the Berne Convention has been the most important international copyright treaty in the world, and that was enacted in 19th century. And then the Qing government realized that the Berne Convention is going to be revised, and then they sent some delegates to understand. So what are the topics that different countries were discussing at that time? Eventually, in 1910, the Ministry of Civil Affairs published a document explaining the necessity of the copyright legislation and important principles that should be included in the law, such as definition, scope, and the duration of copyright. And in the same year, the ministry completed a draft of the Qing Copyright Code, which was later reviewed by the Constitutional Compilation Bureau and the Advisory Council. And finally, the law was officially enacted in December 1910. That is a very brief introduction to the legislation process. And then I will tell you, so what are the factors that really influence this enactment of Qing Copyright Code? We start from external factors, as so people were debating. So what were the roles played by foreign countries in that Qing Copyright Code? Foreign factors are, of course, very, very important. This is undeniable that copyright was still something new to China, to Qing Dynasty at that time. And that was something foreign. Of course, why China started to learn about copyright law? They, of course, learned that from foreigners in China. So a very important group of people that advocated for the idea of copyright protections was that foreign commissionaries. So we have foreign commissionaries at that time. Their footprint had spread across the country, played a very important role teaching Chinese people about Western values and ideas. And that, of course, includes the idea of copyright. And there's a key person in that movement among these commissionaries. His name is Zhong-Bianchi. He was an American, and he was also a commissionary, American Methodist missionary with the Chinese name. He actually spoke fluent Chinese. His Chinese name was Linle Zhi. In year 1868, Allen founded Church News, later renamed as Global Magazine and the Review of Times, which was a religious journal with very, very broad readership in China. And with that publication, Allen also used that as a vehicle to spread the idea of copyright. Of course, copyright is just part of the publication. That journal includes a very wide range of topics relevant to Western knowledge, including political science, geography, history, civilization, etc. Copyright was part of them. And Allen persuaded local Qing government officials through American Council to release a public notice prohibiting the reprinting of the works by commissionaries. So that is also very similar to a copyright notice that I just explained that China already had since the Song Dynasty. But the differences of this one is that you can see Allen also include something about the government, and he tried to tell the readers or potential infringers that copyright, if any, is actually authorized and protected by the government. That is recognized by the government. And he later reproduced this notice in the journal to indicate that local government support his copyright claim. Of course, at that time, there was still no copyright law. Copyright code was not enacted yet. But he tried to get the recognition from the government and try to tell others, I don't have the legal right. And of course, there is no law, no statute, but the right was recognized by local governments. Allen and his friend Fan Yi, so you can see that on the picture, who is the first editor-in-chief of that journal from China, published two very important articles about copyright. And these two articles were also widely distributed at the time. So kind of like serving as a very important function to teach Chinese people what is copyright or what is the so-called 版权. The first is this one, the general rules of copyright. Both articles are, of course, in Chinese. The first one published in 1903. The article examined the definition, function, and duration of copyright in Western countries. And these two authors, they argue that copyright was an instrument to reward authors' hard work, and that an unauthorized reprint or reproduction of copyright works should be prohibited and even penalized by the law. And they also believe that all copyright works should be free of use if their term expires. So copyright is not protected forever. And they have a second article published in the same year, also very important, which is the relation of copyright. In that article, they argue that copyright should be conferred to authors as private rights and that the government should take the lead in copyright protection. Copyright should be designed to reward authors' effort and to induce further creation as a very important incentive for creation. And the adoption of Western copyright protection rules was an inevitable trend that could rejuvenate the nation. So if you really want to modernize the nation, you need to have copyright law. So you don't have any other choice. That is a kind of like a copyright awareness first promoted by foreigners in China. And politically, foreign government also wanted to push China to enact copyright law. But the enactment of the law is usually very, very politically costly and time-consuming. Most of the foreign nations did realize that. And so they have a second best strategy, which is to push China to make some promise about protection of foreign copyright work in some treaties. There are two very, very representative examples that I will introduce that later. So Western powers had sought different protection of legal rights in China since the country's first defeat by Britain in the Opium War, as I just explained. And among other rights, foreign powers also paid special attention to copyright at that time. And why was that? Of course, that was not only about China. That was because internationally, different countries, they were all discussing about how to protect copyright because there was a very important treaty enacted at the time. That was the Berne Convention enacted in 1886. And also, that is about China. The second reason, the rising number of copyright works translated and distributed in China. A lot of the foreign works, they were translated in China and they were distributed without the permission of these foreign authors. And Japan took the lead to force China to include a copyright clause in the treaty. So that is the Treaty of Commerce and Navigation between these two countries, which was actually signed in year 1903. And in that treaty, so the Chinese government or the Qing government promised to provide some protection for Japanese citizens. And of course, the category or the subject matters were still very limited. That's mostly for books, pamphlets, maps, and charts, also written in Chinese language. Of course, that the purpose was to avoid or to eliminate unauthorized translation of Japanese work, especially prepared for the use of Chinese people. And later on, in the same year, the United States also pushed China to include very similar provision in the treaty, and also that is the treaty respecting commercial relation between these two countries. So the language that they use is very, very similar. But if you read this clause very, very carefully, you will see. So what China promised to provide was very, very limited. Not only about the copyright subject matter, book, map, print, etc., but also the purpose of that reproduction. So under what circumstances that a foreigner, American or Japanese, can claim copyright under this treaty? So basically, you need to have a work, and that work is especially prepared for Chinese people for education purpose. And if you cannot prove that purpose, your work is still not protected in China. Of course, this is better than nothing. These two countries, at least, they forced China to promise something on protecting the copyright work of their citizens. So what are the implications of these two treaties or the copyright clauses in these two treaties? There are, of course, a number of very, very important implications. Number one, if you read the language actually defined the protection in a reciprocal way, which is that American people can enjoy copyright protection in China, just like a Chinese citizen can enjoy that in the United States. So that being said, so I'm doing this because you do the same to me. So that is the reciprocal protection. Both treaties provide reciprocal copyright protection. Citizens of foreign countries could enjoy copyright protection in China as much as Chinese citizens could enjoy the same protection in their country. And the second very interesting implication is the so-called supranational treatment. Because at that time, China still did not have any copyright law. In other words, non-Chinese citizens could enjoy any copyright protection, even in China. But with this international agreement or treaty, so with that reciprocal protection, the reality would be because Chinese citizens do not enjoy copyright protection, but under some circumstances, foreigners such as American and Japanese, they could enjoy copyright in China. So their protection is much better than what could be enjoyed by the Chinese citizen. That was the so-called supranational treatment. So you provide much better treatment for foreigners than Chinese people, because Chinese people at that time did not have any copyright protection. The asymmetric treatment for domestic and foreign authors may have amplified the motive for the Qing government to enact a national copyright law to protect its own authors. That is very important because more and more Chinese people, they also translate, they also create new works, but they complain, how come that I cannot enjoy copyright protection, but you gave copyright to Japanese and American people? The third implication is, you can see the protection is very limited, as I just explained. So that is very different from what we have in our copyright law. The subject matter is limited, and also the purpose is very, very limited. And because at that time, the Qing government already signed a treaty with most of the European countries, as well as Japan and the United States. And in all these treaties, that included the so-called most favored nation treatment clause, which is that, oh, if you don't promise something at this moment, but later on you provide some privilege, some benefit, you promise something to some other countries, I would be able to get the same benefit. That is the so-called most favored nation treatment. That being said, although the Qing government only promised copyright protection to Japan and the United States, but all other foreign countries who already had the treaty with the Qing dynasty with that most favored nation treatment clause could enjoy the same protection. So the protection would not only provided for Japan and United States, but also for other foreign countries. That is because of the result of the most favored nation treatment. That is the treaty protection. And then something that might be positive, which is that some foreign countries, they do want China to have a more modernized legal system. So if you kind of like improve your legal system, I might give up some of the very important privilege that I previously enjoyed in China. So that is the so-called extraterritoriality. So given Qing's weakness and eventual collapse, foreign powers increasingly forced China to promise to provide the so-called extraterritoriality through their treaties with China because they regarded Chinese law as barbaric. So what is the extraterritoriality? So that are actually just treaty provisions that forcing China to promise that foreigners in China were subject only to their national laws enforced by relevant consular officials. In other words, the Chinese government does not have sovereignty or jurisdiction over the dispute among these foreigners. Also, that might be on Chinese territory. And extraterritoriality fundamentally challenged the legal orders and the legal framework of the Qing dynasty. And Qing dynasty actually lose a lot of respect because you just don't function like a nation state and you give away part of your sovereignty. And at that time, when Qing government realized that was a really bad thing, that was just too late. And Qing government was willing to make every effort to gain back this judicial sovereignty. And foreign powers, they promised, some of them promised to give up the extraterritoriality privilege if China revamped its legal system to comply with the Western standard. Most representative case here is that UK explicitly expressed this expectation in the Mackay Treaty, which was signed in 1902. And then UK made it very clear that China, having expressed a strong desire to reform her judicial system and bring it to accord with the Western nations, Great Britain agrees to give assistance to such reform, and she will also be prepared to relinquish extraterritorial rights when she is satisfied that the state of the Chinese law, the arrangement of their administration, and other consideration warrant her in so doing. If your legal system is modern enough, of course, I can probably trust your court. I don't need to exercise this privilege. I can give this back to you again. But of course, the prerequisite is that you need to improve your legal system. And because of that, if you read all this material during the legislative discussion, many people would argue that, oh, we really need to have a modernized copyright law that will be part of the very important bargaining chip for the future if we want to win back, we want to get back this judicial sovereignty. While the Qing Copyright Code was not the only law enacted as a result of this legal reform aiming to abolish this foreign extraterritoriality, the Qing government's desire to regain the sovereignty and international dignity certainly played a very, very important role in copyright legislation. So these are the main external factors. And now I'm going to the internal factors, which is actually much more interesting. That is also the main part that I deliver in my research, which is that why copyright law is not only fostered by foreign factors and internal factors, domestic, political, economy, also play a very, very important role. Let's first take a look at the public sector, the politicians, and also government officers at that time. At that time, Qing was eager to improve its legal system, and there were a number of very famous intellectuals or government officers, such as Shen Jiaben and Kang Youwei. They advocated to modernize China via legal reform and learning from Western knowledge. If you really need to learn the Western knowledge, you need to learn from the institution, from the political system, and the law. And these are the two people that promote this idea very, very strongly. But of course, their viewpoint is a little bit different. So this guy, Shen Jiaben, his main idea is that if you want to have some legal transplant, the best model is from Japan, because Japan used to like China. So that was an Asian country also influenced by Confucianism, and Japan became so strong. Of course, Western countries, they look much more different from China. And then Kang Youwei sometimes said, oh, probably we should just learn that directly from these European countries. And copyright legislation was part of the legal reform aiming to build China's national competitiveness. And at that time, I think politically, that was a very nice environment for the enactment of copyright law. And why was that? Because number one, compared to many other legislative proposals, copyright seems much more or much less controversial than kind of like proposal like abolishing of the slavery, etc. And most of these high-level government officials, politicians, they were authors too, because in the past you need to be a scholar so that you can become a government officials in China. You need to pass the exam. So they not only read, they also wrote. So they were also authors. So they meant to get some copyright protection. So very famous examples like this is that influential politicians such as ministers Shen Xuanhuai and Liu Haihuan, they both urged that China should establish a copyright regime which explicitly defined the scope of protection and penalties for infringement. And this guy, Liu Haihuan, who was actually also a founder of the Red Cross in China. And some view copyright as a tool for controlling speech and the press. And then that creates more incentive for the government to enact copyright law. And of course, there is still some debate at that time. So which is that if we are going to have a new copyright law legislation, are we going to protect foreigners or not? So we all agree. So that might be good for us to promote our national interests, to protect more international competitiveness. But what about foreign works? The politicians and the high-level officials, so they kind of like diverge on this issue. Some people say yes, the very famous politician, Zhang Zhidong, another one that was Liu Kunyi. So they both say, so if we are going to provide copyright protection, we needed to do this as Western countries. In Western countries, so they also protected foreign works. If you want to learn that system, you need to learn that entirely. So you don't do that in a very, very discriminative way. So you only be very, very narrow-minded to protect your own authors. But at that time, the majority of these politicians, policymakers, they did not agree to provide copyright protection for foreigners. A very representative case that was Zhang Baiqi, who was a very, very important person in Chinese history of education. At that time, he was the Minister of Education, and he was opposed to protecting foreign works because he believed this would hinder access to foreign knowledge and thus thwart modern education in China. The purpose is to learn Western knowledge as fast as possible, probably as cheap as possible. So if we also protect their works, there's no way for us to translate their work very efficiently so that Chinese people can learn that in a very, very fast way. That is the atmosphere in the public sector. Overall, most of the politicians, they welcome the idea of copyright legislation. So what about the private sector? Two major parties in the private sectors. First is publisher, the other is authors. there were two very important publishers. They pushed very hard toward the government for new copyright law. That is the first one is Wenming Press. So Wenming Press was a Shanghai-based private publisher of textbook that used to be the largest text publisher at that time. And however, at that time, Wenming Press suffered huge economic loss because of the unauthorized reproduction. But the very interesting part of that complaint was that so those who reproduce the work without Wenming Press permission was not only the private publishers, but that was more from the government agency. There was a huge government agency that was the so-called Beiyang Official Newspaper Bureau, Beiyang Guanbaoqu. That was a government agency, published newspapers and also published different kind of books. And at that time, the Beiyang Official Newspaper Bureau extensively copied and sold Wenming Press publication for profit to make money. Consequently, the founder of Wenming Press was really annoyed. So he officially filed a petition in 1902 to that Viceroy of Zhili and also Minister of Beiyang, Yuan Shikai, to seek copyright protection. Yuan Shikai was a very important figure in late Qing Dynasty and also in the Republic of China. He was not only a high-level politician in Qing government, he also became the first president of the Republic of China after the Qing Dynasty was overthrown. And then after a few years, he declared that he was another new Chinese emperor after the Republic was established. Overall, Lian Quan, who is the founder of Wenming Press, filed a petition to Yuan Shikai, and hopefully that Yuan Shikai could respond. And Yuan Shikai at that time just released an official document confirming that, oh, the government would protect copyright of the publishers, so it might not be okay for government agencies to reproduce your work without your permission, especially for profit purpose. However, Yuan Shikai's declaration did not stop Beiyang Official Newspaper Bureau from copying at all. Instead, the director of that Beiyang Official Newspaper Bureau, Zhang Xiaoqian, so he some kind of like rebut back that, oh, we did that for a reason. Number one, so far we still didn't have any copyright law. So I'm not sure about the legal basis of your claim made by Wenming Press. Since we did not have copyright law, so there's no right to be protected. And also, why I copied your work, I did that for good purposes, because I am actually spreading the knowledge to the wider public. So that is actually a good reason for public interest. So you have no reason to complain. And then Zhang Xiaoqian also asked Yuan Shikai to revoke the protection of Wenming's publication because the content therein was incorrect, ill-managed, and illegal. Yuan Shikai then kind of just turned a blind eye to Beiyang Official Newspapers Bureau unauthorized copying activities, which means that the Wenming Press works was still reproduced by the government agency, kind of like a copyright infringement. So Lian Quan filed a petition to another government official, that was Zhang Baixi. We just introduced this figure. At that time, he was the Minister of Education in year 1903. And Lian Quan also filed another petition to Ministry of Commerce the next year. Basically, the claim is not only about copyright, it's more about that government should not make use of the work produced by the private parties. Government agencies should not compete with private publishers for profit, and Beiyang Official Newspaper Bureau's copying was not really for educational purposes. You are actually making money, so we all know that. The government should enact copyright law, therefore, in the interest of the whole society. It's not only for me, not only for Wenming Press, but also for the good of the whole country. So Minister Zhang Baixi, so he was the guy that supported copyright regime, but I just explained that he didn't support protecting foreign works, he responded to Lian Chen's petition, and he said that, oh, I agree, it's very important to stop the piracy, and we really need to have a copyright law. So if the work is registered in the Ministry of Education, so we should try to be helpful. But unfortunately, Zhang Baixi just said that, but that was not too much helpful. So that Beiyang official newspaper bureau was still reproducing Wenming's work. The story of Wenming Press and the Lian Quan illustrated the demand for copyright legislation in the private sector under Qing Dynasty. Of course, all these efforts made by Lian Quan and Wenming Press did not seem to be very successful. Then this turned to our second case, which is another very important publisher, that was Commercial Press, 商务印书馆, which still exists here in China, in Hong Kong, and also in Taiwan today. And that actually came from the Qing Dynasty. So this is also a very important person, probably the most important person in modern Chinese publishing industry. His name was Zhang Baixi. So Zhang Baixi was not first involved in that commercial press. He actually initiated a newspaper called Diplomacy Review in Shanghai, which later became a very important platform advocating copyright protection in the country, introducing the Berne Convention and subsequent amendment in Chinese. And Zhang Baixi later became the chairperson and a primary investor of Commercial Press. And Commercial Press was the largest modern publishing house at that time. So Zhang Yuanji was actually previously a politician, but because of legal reform, the failure of the legal reform, so he stepped down from the politics and he became kind of like a publisher, Zhang Yuanji. So Zhang initiated the publication of China's first monograph on copyright law, that is a copyright overview, published by the Commercial Press in 1903. Zhang Yuanji also incorporated copyright practice in his publication business, although there was no copyright law at that time. One of the very famous examples is this one. The Commercial Press included a copyright notice of all rights reserved in its publication, so as early as 1904, and that was for Yan Fu's translation of a book. Yan Fu was a very important scholar and translator at that time. So this copyright notice was very interesting. So that was somehow different from the previous one that we saw in China. So of course, you can see there are 4 Chinese characters around this notice, which is that you are not allowed to reproduce or reprint this work. But in the middle of this notice, they actually include the name or the last name of the author, which is that the rights belongs to the author. It's not belongs to the publisher, but to the author. So this is somehow more close to modern copyright notice. And in 1905, Zhang Yuanji published an editorial expressing his viewpoint on an ideal copyright regime for China. Of course, he also learned from the Western copyright regime, advocating for limited protection of foreign works. Textbooks should be protected by copyright law after registration with the government authorities. Of course, because he was in the same industry with Wenming, Jyh-An, and Lian Quan, so he basically shared the same viewpoint. But he was more open to the protection of foreign works. He agreed with Zhang Zhidong that we should provide some protection. So don't be that narrow-minded. That was the case for publishers. Now you see the Wenming Press, the Commercial Press, and 2 very important people, Lian Quan and Zhang Yuanji. Authors also play a very important role in fostering the modern copyright regime. And the author that we are introducing today is a very famous person. His name was Yan Fu. Yan Fu was a prominent scholar, writer, translator, introduced many fields of Western knowledge, from political science, economics, law, and science to China. And he was also a very productive author and translator. He believed that he suffered personally huge economic loss in the absence of copyright protection. because he was so productive, and many people just copied his work without his permission, without paying him a penny, and he complained a lot. He really hated that. So Yan particularly cared about the relation between the authors and the publishers. So it's not only about the foreigner, not only about the government, but also the publisher. He, as an author, he sometimes feel that he was not fairly treated by these publishers. So at that time, once an author provided his work to a publisher for a price, he assigned the ownership of the work to the publisher and therefore no longer own it. And Yan Fu just didn't feel that was fair. So Yan did not entirely agree with this copyright practice, and he believed that authors should still be entitled to part of the profit generated from the publication. And Yan therefore tried to negotiate royalty with some of these publishers. And he was actually very, very successful in that. In his correspondence with Zhongbianchi. So Zhongbianchi, we just mentioned that, who then was the Dean of College of Translation in Nanyang Public School. And Yan said that, oh, I hope that I can get 20% of the total profit generated from the publication of my translation. And you know, this is a very important book that I translate. The original one was written by Adam Smith, and I translated it into Chinese. So this is a huge work. So you should give me some more. So Zhongbianchi was much more open to this kind of like Western idea of copyright. So you might remember that he did something with the commercial press. He became the primary investor and founder of the commercial press. And Yan Fu also explained to Zhongbianchi that the royalties could incentivize more scholars to produce new works and to translate Western knowledge. So which is actually good for the publishing industry and good for the country. So Yan's translation of The Wealth of Nations was eventually published by Nanyang Public School Press with the support of Zhang Yuanqi. And Yan, as he wished, obtained 20% of the profit as a royalty on top of the initial remuneration of the 2,000 taels of silver. That was actually the first copyright royalty payment in Chinese history. And not only that, there was also a very interesting story between Yan Fu and Lian Quan from the Wenming Press, if you still remember. Yan Fu authorized Wenming Press to publish his translation of also a foreign book by Herbert Spencer, The Study of Sociology. And he was writing letters to Lian Quan to negotiate for better treatment for authors. And according to Lian Quan's letter to Yan Fu, Lian Quan eventually agreed with this copyright payment arrangement. Number one, they both own the copyright of the translation, this co-ownership of this copyright. And Yan Fu would obtain 7 cents per piece published as royalty. And the publisher had to return the copyright to Yan Fu if the former sold out the stipulated volume of 2,000 copies or failed to pay the later royalties. And should the publisher have failed to include the copyright notice provided by Yan Fu, the omission would be viewed as copyright infringement, and which would incur a penalty of 2,000 taels of silver on the publisher. So that was kind of like, looked like a copyright agreement. Legally speaking, we might view that as copyright agreement because that is exchange of letters, physical letters. So you might view that as an offer and acceptance. So that was pretty modern, kind of like a copyright license arrangement. And later on, with this successful negotiation with Lian Quan and the Wenming Press, Yan Fu become kind of like more kind of like bold. So in negotiating with different publishers. And then Yan signed the first written publication agreement in China with commercial press in 1903. When he authorized it to publish the translation of Edward Jenkins' History of Politics. He basically just told commercial press that, oh, I have this arrangement with Wenming Press, and Lian Quan was fine with that. if you don't take this term, I can just go back to Wenming Press. Wenming Press would be very happy to publish that and accept my my demand on copyright payment. Commercial press eventually decide to do that, and then they sign an agreement. So it's not only exchange of letters. So that was the first official written publication agreement with the concept of copyright in China. So the agreement basically just looked like Yan Quan's letter to Yan Fu, which include the copyright co-ownership, and also 40% of the total profit should be the royalty. Copyright notice should be included, otherwise the publisher would be subject to a penalty. That is the story between Yan Fu and commercial press and the first copyright agreement in China. There was another very interesting story also between Yan Fu and Zhang Baixi. So Zhang Baixi was a politician that promoted the idea of copyright, but who didn't like the idea of protecting foreign works. And then he and Yan Fu had some very interesting interactions. So their interaction first started from this Imperial University of Peking. That has nothing to do with copyright law. At that time, Zhang Baixi was the Minister of Education, and he was responsible for defining a new education system for China. So he mirrored the Western idea of having elementary school, secondary school, middle school, and then college. But at that time, China did not have that. China only have kind of like the private tutor school for young kids. And if you want to become government officers or politicians, you study on your own. You study all this Confucius word, and then you went to Beijing to take this centralized exam. You might be successful, and then in the end of the day, you will be appointed as a mayor or something. At that time, Zhang Baixi was reforming the Chinese education system. Zhang Baixi first designed this Imperial University of Peking. That is the first university in China. After the Qing Dynasty, the university became Peking University. So that was the predecessor of the Peking University. And Zhang Baixi hired Yan Fu as a professor in that Imperial University of Peking. And after the Qing Dynasty was overthrown in year 1911, the name was changed to Peking University because the new Republic of China, they didn't recognize there's still any imperial element. So the name need to be changed. And Yan Fu became the first president of Peking University. So that's their relation from the Imperial University of Peking, or Jingshi Daxuetang. So what's the relevance with a copyright? Yan Fu wrote to Qing policymakers, especially Zhang Baixi, who is in charge of education, and he suggested to prohibit unauthorized reprinting by building a modern copyright regime in China. He also argued the disrespect of copyright would discourage translation of foreign works and therefore undermine China's access to Western knowledge. And Yan Fu also claimed that authors and translators would be disincentivized to produce knowledge if those greedy publishers could reprint valuable works with the permission by the former. So Zhang Baixi, as I said, promoted the idea of copyright very actively at that time. So from what Zhang Baixi said and from what he wrote, you can actually easily tell that a lot of his idea about modern copyright regime was influenced by Yan Fu. All right, that is the internal factors, structure and content. I will go this very quickly. So basically, as I just mentioned, at that time, Qing Dynasty was pushing forward the legal reform, that is the so-called legal modernization, primarily based on foreign laws. If you read the Qing copyright law, so of course we have some empirical study indicating that over 90% of the code was actually translated from Japanese copyright law. And there are 55 chapters, 5 chapters, not 55, 5 chapters and 55 articles. They have an authority in charge. They just look like modern copyright law, but however, it was silent in the copyright protection of foreign works, which was strongly advocated by foreign countries. So at that time, a lot of these foreigners who worked and invested in China, they were very surprised to see the final draft of Qing Copyright Code because they were expecting something good for them. But surprisingly, foreign interests or foreign copyright words were not mentioned at all. So that was what we see from the content of the law. And then the other interesting thing to see is that how the court applied the Qing Copyright Code. There was a so-called mixed court in Shanghai that was established in 1864 with the purpose of protecting foreign interests concerned in cases either civil or criminal. And the court still existed after the Qing Dynasty. And the court decided two very famous copyright disputes about foreign works. The first one was the Jyh-An versus commercial press. And then in that case, that was actually an American publisher that claimed copyright infringement over its book, General History for College and Higher Schools against commercial press. Commercial press did publish the Chinese translation of that book, but without the American publisher's permission. And then the Jyh-An brought this case to the mixed court, claiming for copyright infringement. The court eventually ruled for commercial press and deciding that there was no copyright infringement for a number of reasons. Number one, that case was decided in very, very late of the Qing Dynasty, the last year of the Qing Dynasty. That was the 1911. And the court said the foreign works were not protected by the Qing Copyright Code. So we read through the statute and we realize that only designed for Chinese authors or translators. It's not for foreign owners. And China did not sign Berne Convention. Berne Convention did require the contracting parties to provide protection for protection of the citizens from other members. But China was not part of that convention. And the only law that we might apply here was the 1903 treaty, as we just mentioned, the treaty between China and the United States. But in that treaty, the copyright protection was very, very limited. It only protects the foreign works, specially prepared for use and education of the Chinese people. But in this case, we just didn't think the work owned by the plaintiffs was in that category. So we did agree that the defendant here reprint your work without your permission, but unfortunately, you did not enjoy any copyright here in China. So that was the decision made by the mixed court. And later on, after Qing Dynasty was overthrown, so there was another case. So also a copyright dispute between commercial press and an American publisher. So the American publisher in this case is GNC Marion. So that was the copyright owner of this very famous Webster's Dictionary. And then the publisher was planning to have the Chinese version published in China. But when preparing for that publication, so it was shocked to find that the commercial press has already released its own Chinese version. So the left-hand side was the plaintiff's work, and the right-hand side was the translation that was already conducted by the commercial press. And then, of course, that American publisher was very angry, and then just brought this suit against commercial press, also in the mixed court in Shanghai. And the mixed court in Shanghai just delivered a very similar decision with very similar reasoning as what we just introduced in the Jyh-An Co. Versus commercial press, which was a 1911 case. So if you combine these two cases together, then you can see still, number one, the Qing Copyright Code did not protect foreign works. And number two, it's very, very difficult for any foreigners to claim copyright infringement in the Chinese court under Chinese law. So that was something also about the case. So at that time, the commercial press was really worried that the court might make a very, very different decision because that was not under the Qing dynasty. And politically, China was kind of like in a mess at that time. So that was why the CEO of commercial press, he even wrote a letter to Minister of Foreign Affairs in China. And he tried to convince the Minister of Foreign Affairs to intervene into the case. Otherwise, he said, oh, if foreign works are protected here in China, that will be a huge harm to the Chinese sovereignty. But of course, eventually, commercial press won the case, so that was not an issue anymore. But it was very interesting to read this letter that he sent to the Minister of Foreign Affairs at that time. All right, so Chinese copyright law basically in Qing Dynasty and also early the Republic of China did not provide any protection for foreigners until the enactment of the Copyright Act of the Republic of China, which was already 1928. That was what we learned from studying this statute and the court decisions. So, what is the implication? So as a copyright scholar, I actually have some very interesting observation from all this development. Number one, so of course, China, especially the Qing Dynasty, has its very unique way for copyright legislation, but it was somehow not that unique. As we understand from Tang Dynasty, from Song Dynasty, or even Qing Dynasty, the initial idea of having that kind of a regulation to prohibit any reproduction or reprinting of information or material, so that is for the purpose of government control. You can say that is censorship or control of speech, but that is actually not unique in China. UK had its first copyright law, which is the first copyright regime in human society more than 300 years ago. And before that, for those who study British copyright history, we all understand that the so-called Statute of Anne, the first copyright regime, actually came from that stationery company's special permission provided by the government with the purpose to control the printing industry so that the government can keep an eye on what you are going to publish, was that against the government or not. So that is a very interesting comparison. So how copyright law comes from the government control of press. So that is my first observation, so more comparative copyright history perspective. The second observation that I had from the Qing experience was that for copyright importing countries, they usually had less incentive to protect foreign works. At that time, China did not have too much copyright work. More economically valuable copyright works are those translations from foreign works. So they did not have too much incentive to protect these foreigners. And that happened not only in China, but also in the United States. So before early 20th century, the United States was actually viewed as a piracy country by most of the European countries. Because at that time, the United States was still a copyright importing country. So the 1790 US Copyright Act did not protect copyright foreign works either, just like the Qing Copyright Code. And the US did not protect foreign works until the International Copyright Act of 1891, resulting from petitions submitted by novelists such as Mark Twain, who complained about their loss caused by unauthorized reprinting of their works outside the US. So unless to a certain point that you have strong enough copyright industry to export your copyright work to foreign countries so that you will have an incentive to provide equal protection for foreign copyright authors. So that was just part of my observation. And I'm going to conclude this talk very briefly. So number one, of course, as I said, foreign pressure played a very important role in shaping the first copyright statute in China. However, the legislation of Qing Copyright Code was self-conscious in protecting China's own interests. And this can be proved by the fact that the Qing Copyright Code did not protect foreign works as expected by foreign powers. And access to Western knowledge was a key policy goal under the Qing Copyright Code. which protected the copyright of Chinese translators, such as Yan Fu, but not the original foreign authors. And similar historic pathways of copyright legislation can be found in both UK and the United States. All right, that is the end of my sharing. I get back the floor to Lutz.
Thank you very much, Jyh-An, for this great overview of the developments during the Qing and the Republican period, and also the comparative aspects, which I found very, very interesting. Great, and how you have worked out these conclusions that you've just presented to us. If attendees have any questions, please chat them in, use the chat function. We've already received some questions. We have about 10 minutes, 12 minutes now to ask questions, to discuss the presentation. And if you have, as I mentioned, any questions, please use the chat function and let us have your question, which I will then present to Jyh-An. Let me start with 1.5 questions on my own, and then I will continue with the questions which we have already received. The first question relates to the impact of foreign legislative activities. The Qing Dynasty Code and the Republican Code, was there anything, that's the first question, the other half then relates to the foreign influence, was there anything Chinese about it? Was there something which you would say was distinctive in terms of representing Chinese culture, Chinese legal culture? And the second question here is, you talked a lot about Japan, and there was a bit about US. I remember John Allen was a US missionary who started the whole process, but you also mentioned Germany. Which country had the strongest foreign influence on the making of the Qing Code and the Republican Copyright Code? Thank you.
Thank you, Lutz. So these two questions are very interesting. I was also trying to think about, is there any unique thing about China in the Qing copyright code? But surprisingly, as I just said, over 90% of the code were copied from Japan or translated from Japan. So I actually don't see too much with the very strong Chinese characteristic. So if you try to find something that is relevant to China specifically, I would say probably the government agencies that is in charge in the law, that was the new government agency, that was the Ministry of Civil Affairs. And very interesting, they say, because China was so big, if you want to register your copyright work, you didn't need to go to Ministry of Civil Affairs in Beijing. So you can just register your work locally in some of the local governments, and the law still use the term, so very traditional Chinese term, yamen, so to refer to local Chinese government. And for the second question, yeah, I agree that different countries might have different influences on the law. German law and the Japanese law were mostly commonly referred to in this government policy or documents. I guess at that time, German was kind of like a role model for Japan. And as I also mentioned earlier, so there was a politician called Jyh-An. Jyh-An strongly advocated the idea of just learning Japan, because Japan also had this Confucianist culture. And then Japan also went through that process, or any pen, if there's any, learning from the Western. But of course, we understand at that time, Japan mostly learned from Germany. So you can probably put it this way, China still study the German law, but not transplant the law from German directly. But still there is a German influence on the Chinese copyright code, indirectly from Japan. And you are right, John Allen is American, so American idea of copyright was also widely spreaded. And there's another very interesting figure that was Yan Fu. Yan Fu was originally not a scholar. So he was selected by the government to study in UK, but he was sent to a Navy school, so for military training. And then after he went to UK, he was so surprised to read all this English literature, and he decided to become a scholar. So for all kinds of knowledge, science, social science, law, everything, and he went back. And you can see most of the literature cited and referred by Yan Fu, that was actually British literature. And in that sense, I would say the Britain also have some influence on the idea or awareness of copyright in China at that time.
Thank you very much. Next question comes from Shmuel Yerushalmi, and the question is, I want to ask, is it after the first copyright laws in China were enacted, could we see the beginning of a process of capitalization of cultural and art creation?
I do agree with this observation. As I just introduced the story of Yan Fu, so Yan Fu was the person that's trying very hard to capitalize or commercialize all his works, and he pushed very hard, and he emphasized about the idea of incentive. But on the other side of incentive, that was not only for the good of the society or the country, that was actually the personal wealth of these authors or translators. And publishers, they also try to define their business model in a more clear way. And they realized with all this printing technology at that time, they wouldn't be able to make money without the protection of copyright. So that's why they lobby so much to this high-level Qing politicians, people like Zhang Zhidong or Zhongbianchi. They want these politicians to buy the argument so that they can have a more viable business. So I do agree with your viewpoint. So that is kind of like the initial point in which not only authors, but also publishers would like to get more, probably or recruit more from their investment and make that more commercially viable.
Thank you. The next question, the bilateral agreements, such as the one with Japan in 1903, offered reciprocal protection, but China at that time didn't have protection under the Qing copyright code for foreigners. Are there any examples of Chinese authors or publishers attempting to enforce copyright in Japan after the Qing copyright code was introduced?
To be frank, that I don't know. I need to have further study on that. That is a very interesting question. So I do know there were quite a few Chinese people, they live, work, or study in Japan. There is a very sizable Chinese community there at that time, and their social status would be very different from those compared to Chinese people in the United States. So it's possible that these Chinese people who live in Japan, they might have some copyright work that need to be protected.
Thank you. Next question is a short one. It relates to the Qing copyright code. You said on one of your charts that it had 55 chapters and 55 articles. Does that mean that each chapter had one article? Sorry,
that was a typo. There were only 5 parts and 55 articles.
Okay. And then the next question is the impact of the developments in the Qing and the Republican time on modern copyright law in mainland China. I understand you said earlier that the copyright law of the Republican area is still law in Taiwan, but what about mainland China?
So that is a hard question because mainland China had not have any copyright regime after the Civil War in 1949. And that was not until late 1970 when China had that open door policy. And also with the negotiation with its trading partner, especially the United States, so that China started to reenact a new copyright law. And many people would say, so that was for the main purpose of joining GATT or WTO. But if you try to draw kind of like an analogy between what China now has with regard to copyright protection and compared to that time, I do see some kind of like very interesting thing, which was that so ever since China started to open the door in late 1970, foreign factors play a very important role in the modern copyright law in China. But if you see the copyright legislation, copyright amendment in more recent years, not only copyright amendment, but also the IP reform in the past 2 years. So it's very interesting to see that the American or the US has been pushing China towards certain direction and asking for more protection. And China, of course, sometimes try to address some of these issues, but not all the issues. And I would say after year 2008, China started to have its own agenda of IP development or national IP strategy. So it's not only about the expectation from their trading partner. China has started to think about what would be best for the country. So about, I think I would say more than 10 years ago, so as early as year 2008. And that was very similar to what we just observed in the development of Qing Dynasty, which was that foreign countries, so they put a lot of pressure on you and they have a lot of expectation and they ask you for this and that. But for Chinese people, once they understand what they really need, what was really good for the country, so they actually have their own determination. So they might probably sometimes address, oh, this concern that we do understand. So this is also our goal. I can do this easily for you. But for others, I would not easily give up, especially at the negotiation table. So that might be something still interesting. So that's somehow relevant to the treaty negotiation and how the foreign trade power influence on domestic legislation.
Great. Thank you very much. Time is almost up. Thank you again for a great talk and a very, very interesting discussion afterwards. Thank you all for joining. It remains for me to announce the upcoming seminars at CUHK Law. First of all, the next Greater China Legal History Seminar will take place on the 11th of February 2022. And the talk will be delivered by Professor Stuart McManus, who is a colleague from the Department of History here at CUHK. And the topic is Early Cross-Border Legal Issues, Law in the Age of Matteo Ricci. Next. We have upcoming next week a seminar organized by the Center for Financial Regulation and Economic Development, CFRED, by our colleague Michelle Miao. Why does a right to explanation matter? A contentious but indispensable legal instrument to regulate automated decision-making. And those who are familiar with the area, this right to explanation is becoming a very, very hot topic in the context of AI and all these new developments that we see in the area of legal technologies. Next. We have, as part of our property law seminar series, a seminar on the 16th of February 2022 from 6 to 7 p.m. Private takings of land for urban redevelopment, a tale of two cities, delivered by Professor Calvin Low from the National University of Singapore, Professor Wanhua Yi, who is the Associate Dean and a professor at CityU, and Mr. Alvin Chan, a Principal Lecturer of the University of Hong Kong. And finally, on the 22nd of February, 5 p.m. to 6 p.m., we are honored by a presentation by Justice Okari, a public lecture on equality in memory of the late Mr. Vincent Connor, who was a very valued member of the CUHK Law Advisory Board and a good friend of ours. Thank you again, Jyh-An, for this great seminar. Thank you all for joining, and we hope to see you again at the next seminar of the Greater China Legal Seminar series. Thank you. We are CUHK Law. Bye-bye.
Thank you, Lutz. Thank you, everyone. Bye.